Buenas tardes. ¿Se oye bien? Deseo, en primer lugar, que mis palabras sean para agradecer a las universidades organizadoras, la Universidad del País Vasco, la Universidad de Valladolid y la Universidad de Deusto, que me hayan invitado a participar en este acto con estos compañeros, acto organizado por lo demás por las profesoras Carmen Herrero, la profesora Julia Suderov, y detrás de las cuales, como es de sobra sabido, está el profesor Luis Velasco San Pedro. Con esos mimbres no se puede hacer más que un buen cesto y por consiguiente era un honor venir aquí esta tarde para compartir mesa con estos compañeros. Debo decir, sin embargo, que intento encontrar una razón para que yo esté aquí y la verdad es que mi presencia aquí me recuerda la canción de Mike Ríos de que los viejos rockeros nunca mueren, porque hace años que yo no me dedico a esto. Sí que debo decir que hace 5 años en que nosotras tres, porque al fin y al cabo yo soy una más, Carmen y Julia, elaboramos el que probablemente fuera el primer dictamen en el caso de camiones. Un despacho nos lo pidió y que yo sepa el primer escrito con forma jurídica y estructura científica que se escribió en ese asunto lo escribimos nosotros. El despacho se quedó con el dictamen que nos había pagado, se anunció en internet y obtuvo más de 5.000 clientes, a cada uno de los cuales les daba pues el correspondiente dictamen que habíamos firmado. Luego desaparecimos, eso es muy frecuente. Una vez que ya has captado los clientes, quieres que se dirijan solo a ti y no que se dirijan a quienes son los autores materiales de las ideas. Me ha pasado varias veces, pero en fin, otro día hablaré del caso Thyssen, donde tengo la sentencia del segundo procedimiento, el único en que ganaron claramente, en la cual se cita un dictamen 4 veces, que es el dictamen que los profesores Mariano Izquierdo y Alfonso Calvo elaboramos. Lo digo porque ahora, con motivo del 4.º procedimiento, incluso hay algún lobby en Madrid que organiza jornadas sobre la sentencia Thyssen y ninguno de los que allí aparece intervino en los 10 años que duró la litigación. Pero bueno, ¿qué le vamos a hacer? Esto es España. Yo, por consiguiente, voy a recordar cómo nos encontrábamos los que ahora somos ya personas de edad provecta cuando empezó a cambiar el paradigma dominante en materia de indemnización por daños anticompetitivos. En realidad, yo recuerdo que cuando leía en la doctrina española había una continua referencia al cártel del azúcar, referencia que estaba muy justificada. Sin embargo, hoy no se habla tanto del cártel del azúcar como del cártel de la leche. Hoy, ayer y hoy, por razones que muchos conocen, se está hablando de nuevo del cártel de la leche y, por supuesto, es actualidad constante el cártel de los camiones, sobre el que versaba nuestro dictamen. Y eso está justificado, porque con esos casos empezó a verse 2 cosas. Primero, la complejidad de la materia y segundo, el camino que teníamos por que recorrer. El cártel de la leche, seré muy breve, realmente saltó a la escena en marzo de 2015. Era un cártel que había durado 14 años. Había durado del año 2000 a 2013. Por consiguiente, era un cártel de larga duración, de tracto sucesivo, que ponía en evidencia la ineficacia del sistema. Se habían estado riendo de la normativa existente durante 13 años y no se rieron más porque Dios es misericordioso y debió iluminar a alguien. Los integrantes eran 15 empresas y 2 asociaciones regionales. Si se pasa revista, estaban todos los grandes. Puedo enumerarlos, pero basta con que ustedes cuando desayunen y tomen un producto lácteo lo miren. Casi seguro que es Lactalis, Puleva, Danone, Pascual y Capsa. Es decir, no iban por ahí, no digamos que no eran empresas pequeñitas, de estas que pecan por imprudencia, que es lo único que falta ya alegar en defensa de los cárteles, que lo hacen sin mala voluntad. Sus prácticas competitivas anticompetitivas eran 4, de libro. Reparto del territorio, reparto de los proveedores, intercambio de datos estratégicos, del estilo de en el mes de septiembre voy a subir el precio del litro de la leche, pues 30 céntimos. Casualmente todo el mundo subía en septiembre el precio de la leche 30 céntimos, pero sin mala voluntad. Era un movimiento en paralelo de empresas con una estructura de costes muy distinta que sin embargo producían el mismo resultado en el mercado. Y luego había un descenso de la calidad para abaratar costes. Digamos que lo que se ahorraban en leche lo gastaban en agua. El producto perdía densidad y en España, donde en general los productos lácteos, salvo el queso, no gustan mucho, pues digamos que hacía que el gusto se adaptara más, no al gusto europeo, pero sí al gusto español, que tiene esos yogures blancos que son absolutamente insípidos. Bien, la Comisión Nacional de los Mercados y la Competencia reaccionó con bravura, algo hasta aquella época poco frecuente, y le puso una de esas sanciones que salen en los periódicos, 88,2 millones de euros. Todo estaba bien, salvo que uno se preguntase qué beneficios ilícitos había obtenido este grupo de empresas. Pues habían obtenido 815 millones de euros. La sanción escasamente superaba el 10% de los beneficios ilegales, no de los ingresos, no de los beneficios, sino los beneficios ilegales, el overcharge. Era realmente preocupante. Y era más preocupante que la empresa navarra que denunció el caso dio suspensión de pagos. Es decir, antes fueron ellos expulsados del mercado que recuperar todo lo que le habían ilícitamente quitado. ¿Qué enseñaba el cártel de la leche? Pues el cártel de la leche, que así dicho literalmente en español suena muy mal, pues enseñaba que en una economía cartelizada incumplir la ley podía ser muy rentable. Esto se dice en todos los cursos de economía industrial, pero hay que ver un caso concreto para darse cuenta que antes que ir vendiendo mascarillas falsas y cosas así, lo que conviene es montar una central lechera. Luego vino el cártel de los camiones. El cártel de los camiones hace su aparición el 19 de julio del 2016. En el cártel de los camiones nos encontramos, el anterior recuerden ustedes que era un cártel nacional, interno, con implicaciones europeas también, porque si cierras un mercado nacional, cierras una parte sustancial del mercado interior. El cártel de los camiones surge el 19 de julio del 2016 para la opinión pública. Resulta que es un cártel que duró 14 años, desde 1997 hasta 2011, y sus integrantes eran fabricantes de camiones medios, es decir, de 6 a 16 toneladas, y de camiones grandes, camiones de más de 16 toneladas. Había marcas conocidas con una larga trayectoria en la actividad industrial. MAM, que era el chivato, el fabricante de chasis de camiones por excelencia en Europa, era el que se había soplado y denunciado a sus compañeros. Luego estaba Volvo Renault, que fue multada con 670 millones de euros. Daimler con 1.008, Iveco con 494 millones y DAF con 752 millones. ¿Qué prácticas anticompetitivas tenían? Prácticas también de libros. Son de esas prácticas que cuando se las cuentas a los alumnos piensan que el profesor ese día se ha equivocado de licor a la hora de echarle al café algo que lo anime. Había acuerdos de fijación de precios. El malo de la película. Había repercusión de costes de la normativa medioambiental. Es decir, hay que hacer motores menos contaminantes, productos menos contaminantes, sean metálicos o de goma. Bueno, no importa, se le repercute el 100% y si es posible el 110% al consumidor y así con el tiempo le daremos productos de calidad. Con la calidad también se compite. Y sobre todo se había pactado el calendario para su introducción, con lo cual al final quien tomaba las grandes decisiones que mejoraban el bienestar del consumidor europeo eran los destinatarios de las normas y no los creadores de las normas. Este es un cártel europeo. ¿Qué repercusión tuvo solo en España? En aquella época, estoy hablando de 2016, que en el calendario está muy cerca, pero en el conocimiento de la materia está muy lejos, pues debo decir que éramos unas personas a las que nos faltaba mucha experiencia en esto. No tenía que ver con que supiéramos mucho de derecho comunitario. Es que nunca nos habíamos encontrado, al menos que yo sepa, en la práctica española con casos tan complicados. Solo en España se calculaba que había unos 300.000 vehículos que habían sido afectados por el cártel y 100.000 de ellos en los primeros meses ya habían reclamado. Otra cosa era el sobrecoste medio del precio. Se calculaba que entre un 10 y un 12%. Eso suponía un 13.000 a un 16.000 euros por camión. Es decir, se reclamaba, según los cálculos, ampliamente superados después, en aquella época, unos 1.000 millones de euros a los fabricantes. Nunca en la historia española habíamos tenido un caso de daños anticompetitivos tan voluminoso. Y eso era algo que llamaba la atención, porque hubo un excelente congreso en la Universidad de Valladolid en la que fue curioso que mientras la mayoría de los allí presentes, empezando por los organizadores, el profesor Luis Velasco Sampedro, se miraba con entusiasmo una nueva normativa y asistió el propio comisario de competencia, señor Almunia, en aquella época, hubo, sin embargo, algunos ponentes, recuerdo en particular a un catedrático de Derecho Civil, que luego ha sido magistrado del Tribunal Supremo, y a un catedrático de Derecho Mercantil, que actualmente es magistrado de lo civil también, que sin embargo pensaban que no había por qué traer una nueva normativa, que el 1902 del Código Civil, la ley aquiliana típica del derecho romano, lo resolvía para todo. Debo decir que a quienes sostenían esto en aquel momento no eran magistrados del Tribunal Supremo, sino abogados de importantes bufetes. Si hubieran tenido en cuenta una lección de economía industrial que durara solo 5 minutos, creo que no podrían defender esa conclusión sin que se les cayera la cara de vergüenza. ¿Qué nos enseñaba en aquella época ya la economía industrial? Pues la economía industrial nos enseñaba dos cosas. Las ganancias de un cártel van generalmente entre un 15% y un 20%. Es verdad que hay cárteles con mucho más, hasta un 40%, pero no es lo habitual. ¿Por qué no es un porcentaje menor? En la tesis de Julia Suderov recuerdo que había un cartelista entre el público. ¿Te acuerdas? Dije, además de los doctores presentes, ¿hay algún profesional de la constitución de cárceles? Y hubo uno que levantó la mano y dijo, sí, yo. No se avergonzaba, era un hombre de negocio. Dijo, luego hablamos usted y yo. ¿Te acuerdas, verdad? Y le dije, oye, ¿por qué siempre cobráis entre esto y esto? Y repito literalmente lo que me dijo en privado, esto no lo escribiría en la academia. Me dijo, pues mire, don Alfonso, le voy a decir la verdad, porque si uno se mete a puta es para pagarse los vicios. Es decir, no podía cobrar menos porque si te metes a eso es para ser rico. Y no podías cobrar más porque el tipo se conocía, aunque él no lo supiera, era como Monsieur Jourdain, aquel personaje de Molière que hablaba en prosa sin saberlo. Este conocía la teoría de los mercados disputables de Baumol-Pansarivili. Sabía que si un mercado monopolístico o oligopolístico genera muchos beneficios anticompetitivos, acaba yendo mucha gente y te cargas el negocio, lo conviertes en atomístico y perfectamente competitivo. Y tampoco se trata de eso. Y luego la segunda cosa que enseña es que los beneficios de un cartel internacional son entre un 30 y un 33% y de un cartel nacional entre el 17 y 19%. Es decir, cuanto más sinvergüenza seas, más incumplas la ley y más maña te des con esto, es más rentable. Es decir, no robes un pobre, atraca un banco. Ya. Entonces, ¿qué conclusión se saca con esto? Y con esto voy a acabar, tranquila, Julia, que te va a dar algo. O se lucha con un sistema de sanciones públicas más sanciones privadas, o los actos competitivos son rentables. Hemos estado con los ojos cerrados, tapados. Hemos mirado a otros lados, pero hoy no me meteré con las eléctricas y menos con las que pueda haber por aquí cerca. Entonces, ¿qué me recuerda esto? Pues esto me recuerda que Luis de Brandeis, el primer judío que llegó en Estados Unidos al Tribunal Supremo, dijo muchas frases afortunadas, pero una de ellas era: un jurista que no ha estudiado economía y sociología es muy apto para convertirse en un enemigo público. Y eso es lo que ha ocurrido. Aquí se nos han metido aficionados que ni saben derecho ni saben economía industrial. Y ni si no sabes derecho ni sabes economía industrial, puedes dedicarte, pero a otra cosa, salvo que quieras ser el enemigo público número uno. Eso es todo. Muchas gracias por vuestra atención. ¿Queréis preguntar algo, hijos? Perfecto. Me voy a mi sitio. Muchísimas gracias. No, es que me quedo ahí por un tema que tiene que ver con mi salud. ¿Sabes? Es que tengo todo. Mi familia, tengo cardiopatía isquémica, hipertensión, diabetes. Mi familia quiere vender mi cadáver a los americanos para que lo estudien cuando ya no esté.
Okay. Well, thank you very much. I'll start. Of course, I will sit you. I will let you have the floor in a minute. I'm Patricia Vidal. Of course, I have to do the disclaimers. In this case, in particular, I'm acting as a defendant of Track's case for DAF. So I cannot disagree more with Alfonso, as you can imagine, of course, because with a post. I've been applying for leniency for 25 years, I think. Well, not 25 because it did not exist, but I was the first applicant of leniency with a new regime. I've been the claimant in the sugar cartel case. I've seen many cartels, and I can perfectly distinguish a hardcore cartel than a cartel, but which is not hardcore. So I don't think that all cartels are equal. I think I have colleagues and friends here who are competition lawyers, and they have seen many things. You cannot treat all cases equally. You cannot have general rules. You cannot simply say a cartel necessarily causes harm and by average 30% or 40%, even if it's international. I'm not here, of course, defending the case, and I will not discuss the tracks on the merits anymore, but I'm really at least upset because what I always hear is the same story. There should always be a damage here because they're all bad, but I have seen very bad things. Market sharing agreements, they're bad. Price fixing agreement, hardcore price fixing, boycott. I was in the decennial insurance case as well. So, I mean, I've seen very bad things. Tracks, they have a sanction. Of course, they have a sanction. It was illegal. That is not the worst things I've seen. So I think we should not treat things the same way. And I think there's a right of defense and a right of defense of presumption, not of innocence, but here, if you have a claim for a damage, you have to prove it. It's not a price fixing. How did we discover the sugar case? And I'll tell you how, because I was the one revealing that to the competition authority. As you said in the milk, prices increases the same day with the same excuse, the same letter, same price. So the effects of the agreement reveal the existence of the agreement in itself. And we went with that to the authority. And then you get internal information, down rates, people saying, we have increased above the price that we could have increased. You also have it in the envelopes case. Then I fully agree, you cannot say there's no harm, even the cartel is accepted. But apart from those cases, as a general rule saying that an exchange of information with agreements, because there might be agreements, we were discussing this before. I don't know whether they affected Spain or not. By its very nature, it will have caused a harm. I can tell you, I've seen many stupid people exchanging information for stupid reasons, but with no effects at all. I tell you the case, for instance, that is mentioned in many proceedings is the bathrooms and fittings case. Well, I was there and I applied for leniency. There were 10 years of exchanges of information that were excluded from the statement of objections because there were simply exchanges of information on, I will increase 2%, the other will increase 1%. Until there was an agreement, there was no sanction for that. So even the European Commission was not sure whether it could cause harm. So I'm simply saying this because unless you have a hardcore cartel case, which are the ones that you're probably referring when you say 20% average damage, you cannot by nature say there should always be a damage, and much less of 15%. Because then why do you have a court? Why do you have a proceeding? Just say 10% or 15%. This is a guesstimate. It's not real evidence of that. I'm sorry that I acted as a defendant, but I think I merited it because that's what I heard before that. So give it. Yo misma. So I was supposed to discuss. ¿Cómo se hace esto? Le estoy dando, pero no funciona. Okay. Yeah. Okay. I have simply. This is the only single slide, so we can adapt. And we can discuss. It's the different things that as a claimant or as a defendant one can think when suing in one jurisdiction or in another when you have a transnational case. And I think we can, of course, start discussing forum shopping if you want, and I will let you the floor. My introductory comment is enlargement of the range of potential claimants, because if you enlarge the potential claimants, then you have more jurisdictions to choose. Of course, if you're in a follow-on case, you have the addressees of the decision, sanction and decision, that's obvious. But you can also go against the parent company, even without the Article 71 of the new law. I strongly believe that, and much after Skanska and Sumal. You can also go for the successor of the company, of course, and now with Sumal, under certain circumstances that I put here, Sumal's limits, you can go against the affiliate. But it doesn't mean, and I've heard in some forums, and that's why I want to make this point, It doesn't mean that you can go everywhere in Europe to see where there's an affiliate and you go there and you sue. No, you need, of course, to prove that there is an economic unit of that affiliate. And secondly, that it has marketed the products in question affected by the claim. There's a debate here, and I think there are different opinions on whether it is necessary that the affiliate markets the range of products of the parent company affected by the infringement, or the other alternative is that the affiliate marketed the precise product that is affected by the claim. I believe is the second one. I'm using the same arguments that we use when you have extortion of rights. For instance, in intellectual property, you can only say that this product has been illegally marketed if it's that product, not the range of products. So here I'm saying the same. If you have several affiliates selling trucks or cars, you should sue the one that has sold the truck or the car affected by that claim. But it doesn't mean that you can go everywhere. And with that, so we have many potential addressees of the claim. So you may multiply the possibilities of suing in Spain or in many other jurisdictions. And that's where we have now the different rulings on foreign shopping that definitely they are relevant for deciding where to sue. Because the defendant has not many ways to defend.
You're being sued.
Exactly.
Yeah. No, I think it makes sense. I mean, the topic is, of course, transactional or transnational actions. As to the introduction, I will not comment on the trucks case on the merits now, but we focus on let's say the transnational jurisdictional elements. And Patricia, you rightly said, okay, any case I think starts with the claimant. So I think it makes sense to set out a little bit the ideas or choices that you have as a claimant. And as you also said, I think in the meantime, the choices expanded. And when we started our first transnational case, which was the hydrogen peroxide cartel case, a really traditional hardcore cartel, like a real nice hardcore cartel.
I agree. I fully agree.
With cartel members based in 6 jurisdictions across Europe. We choose to sue Degussa at its seat in Germany, and we also sued in Germany the other cartel members, which did not have their seat in Germany, but in either Finland, Sweden, the Netherlands, France, or Spain. So, of course, the key debate was, is this possible? And I think we at the time had assumed that you have jurisdiction at least at the seat of every addressee of the commission decision. And that was already a conservative approach, I think. So it was not at a random parent company or subsidiary, but really at the addressees. And as you know, the commission decision typically specifies the individual entities that are liable for the administrative fine. So we mirrored that in our submission and argued that, okay, for Degussa, you have the seat at the headquarters of Degussa, in which the competent court was at Dortmund. That is quite normal. Everybody agreed to that because it's in Brussels 1, Article 2. It's the seat of the infringer or of the opponent. But then the big question was, of course, do you have jurisdiction as well to bring the claims against Akzo Nobel, which has its seat in Amsterdam? And that debate was taking more than 5 years until we finally got a judgment by the European Court of Justice, which confirmed that due to the special jurisdiction of Article 8(1) of the Brussels 1 regulation, and due to the joint and several liability of the infringers, you can join all of the infringers or addressees at one and the same court. Interestingly, we then settled with, or in the meantime, we had settled with Deusto, and the European Court of Justice confirmed that also, which was the anchor defendant, the European Court of Justice confirmed that the jurisdiction of the court ceased stays, even if you settle with the anchor defendant. Then, so these are choices that you have in a cartel case. Typically, you have more than one infringer. So typically, you have choices. And I think that's important to say. It's not that we invent this. It's the fact. It's the result of the pan-European infringement. Secondly, you had then in Article 102 cases, which typically concern contractual elements, cases in Fly LRL and Wikingerhof concerning contractual arrangements with Booking.com, for example, where you had in the contracts that they signed with Booking.com, the hotels, a clause for exclusive jurisdiction of Amsterdam. However, Wikingerhof, a German hotel, decided to bring its claim against Booking in Germany. And based on an infringement of Article 102, and the European Court of Justice held that, yes, you have the right to sue at your place, the seat of the victim, because of the forum delicti under Article 7.2. So this opens again additional jurisdictions. Then what Patricia already mentioned, Sumal, it's also, of course, very important. There we're talking about entities, legal entities, which are not named in the Commission decision. The European Court of Justice held, yes, you can sue at the seat of the subsidiary, even if it's not named in the Commission decision. So you could go to Barcelona. If you have at least marketed the same product. And I'm not really sure whether me as a claimant, I would now choose, I would always go for a conservative approach, because I mean, the worst thing is you can argue for 5 years what happened in our Dortmund case. Do you actually sue in front of the same court, in front of the right court, and you lose years and years. And even on our first cases in Amsterdam, we were discussing for 3 years whether or not there was competence. It's not an issue anymore in the trucks case. Interestingly, that was never challenged. Jurisdiction was not an issue. So I think there is also development of case law, and then this gives legal certainty, and I think that's important. So you have choice as a claimant, and I think it makes sense to say, I mean, the question is also not forum shopping, is it good or bad? I think it's just a fact that you have alternative jurisdictions. It's also what Advocate General Yaskin said in our CDC hydrogen peroxide case, basically to exercise that option in the manner the claimant considers most suitable and advantageous. So in the end, it's a right of a claimant to choose the jurisdiction where you think you're best served for your own interests. I mean, and that is a right of any claimant. So what are the relevant factors if you look like from our side as a claimant? Typically, I mean, we haven't acted on the defense side yet. So
it will come.
So I think the main element is really that you choose a jurisdiction where you have certainty regarding the outcome, or as much as possible, at least. I mean, we all know you're never certain to win a case, or to lose a case. But I mean, you choose, of course, a jurisdiction where you think, okay, there's an explicit case law, there's experienced courts. And if you have that, then you may have elements such as, yeah, what is the timing of courts? How quick do they decide? How effective do they handle the procedure? Is it possible to hand in electronic data or data in electronic form? In our first case in Germany, we submitted printed invoices. It was a truckload because they simply didn't accept, the courts couldn't deal with electronic formats. And the same happened in the trucks case, I think, in Stuttgart. There's photos of trucks delivering the submissions with printed out invoices, which are the basis of the damage claim. So nobody's going to look at that. And some judges are complaining that the statics of the court building may be negatively affected by this. But I mean, that's how that are relevant thoughts when you think about bringing in action. Yeah, I think overall we see there's still large differences in Europe, but there is also conversion. I think the judges are dealing with the same problems. What I think is encouraging is that judges are exchanging views, exchanging experiences, and I think that's a positive development.
Am I on? Thanks. I have two remarks before I actually just add on to what Till said. We should have shared our presentations before, so no need to bring my presentation up there because a lot of things you mentioned are in there. But I like this more of a freestyle discussion. I think it's beneficial for you as well, and I invite you even to have questions. If you have questions in between, even between while I'm speaking, please interrupt me because I think this is how we should conduct this late afternoon session. Second remark, I already told Patricia, I'm not agreeing with the labeling hardcore cartel or not hardcore cartel because I think this doesn't help anyone and it's outdated. Let me explain why. And we had this point in the morning, why are there a big reduction of leniency applications, right? There's a million of reasons. Can be also that compliance is working. Can also be that the way cartels are formed and built has evolved because markets have changed. We're talking about digital markets. I bet you that the digital markets, the way cartel agreements function will differ 100% from the cement cartel, just because the markets are different. If we talk about trucks, my personal takeaway from trucks is the cartel could have only, let's not discuss if it's an information exchange or cartel, but let's say the infringement could only take place the way it did because it was a producer cartel or infringement, right? There was no way this could have been concluded on the retailer's side. No way of surveillance, no way of even exchanging information about whatever, 100,000 sales agents I'm exaggerating. So I think, and that is actually my thesis for longer, that the categorization of hardcore cartel or not will not help us solving the cases to come. And maybe, and this is where I want to make a point, the information exchange is the new price agreement of the future. Because all there is an information exchange, but it is enough given the modern means of steering your sales, the modern means of communicating to each other without really communicating, the fear of the compliance department in your own company. So, and we've been trying to convey that message to the court. And fortunately, so far in like some German truck judgments, you don't find reference to the hardcore cartel definition because you don't need this anymore. But this is just my opening. And then let me maybe shed a light on, of course.
This is a joke. This is diversity. This is a real example of diversity that is so old-fashioned. So that's good for discussion.
And maybe evolution of legal standards, or let's say principles that for a long time have been acknowledged as being the principles. Also economically wise, when I talk to economists, they say, we didn't define the term hardcore cartel. This is European legislation. Some came up in the vertical or the horizontal. That's where they can. No economist has defined hardcore cartel term. So this makes me wonder, as a lawyer who's needing to talk economics to the judge, forget about hardcore cartel. It's the nature of a single infringement you have to investigate, and there is the theory of harm, which will lead either to success or to disaster, depending on how do you produce it. Forum shopping. Allow me to have here the let's say a little bit the German perspective, which is boring. Kill the attention, please bear with me, because Germany is not the most attractive jurisdiction for large lawsuits. You mentioned the Legal Service Act problems we have. You mentioned that despite all the, let's say, warrants you earned there as CDC, paving the way, right? You always had to fight hard because assignment model, no one likes. So I had a hard time finding interesting, or at least cases at all, recent cases that are kind of a forum shop cases, meaning claimants from other jurisdictions claiming in Germany. I didn't find many. I'll go to them in a bit. But I also would like to look at the forum shopping point from the perspective of the legislator. And that is what I miss in Germany and what I complain about when talking to the legislator. You need to be open to attract claims in your jurisdiction, right? You have to want that. Otherwise, as a legislator, you block that. And that's what we see actually in Germany. We don't see any, we are way behind in the terms of establishment of collective redress mechanisms. That we agree, right? Having listened to Jost, the model jurisdiction right now, or even in Spain or France, like you mentioned this, you are way advanced compared to us. Are we giving up now? No, we still have our ways, like the assignment model will hold, but we don't have legal certainty. We are working the legislator to improve the conditions for, right? And then maybe in the future, we will also have an attractive place of jurisdiction, which is Germany. But right now, or from a practitioner view, I cannot say we are a very attractive jurisdiction. But of course, there are traditional, and Maria Jose mentioned this as well, and this is interesting when you're listening like comparatively to others, that are in place that we are using in the practice, right? Joinder of parties, it's traditional. Like we were going to launch a joinder claim with more than 3,500 claimants in the cartel case in Germany. The only thing is you have to talk very thoroughly and good to the investor, because there's a remaining risk that the judge separates the joint claims. And he can do so on, and now that's why we all love law, objective grounds. So you have to assess the risk if you use the joinder of claims. How, or are there any possible objective grounds that the judge can cite to kill your joint action? Because if it's separated, it's going to be a disaster. You only benefit, for instance, and this you have to understand, from the cost digression in our statutory fees when you have a joint of claims. If you separate 3,500 claims, the case is dead, because then individual value of the claim adds to, I would say, maybe triple of the costs. So this is the risk you have when you resort to, am I still on here? To the joinder of claims. But let me now just, so you have heard it, and if you're interested, we can share, of course, the presentation afterwards. The few cases, recent cases, I didn't look in the past 5 years or 10 years, just the past 2 or 3 years of forum shopping I found. There is one which is in the Regional Court of Stuttgart. It is a trucks case. It was Austrian fire brigade purchasers, right? Claiming in Stuttgart because, like we did as well, thought, no, Stuttgart won't be a problematic case, even though Daimler is there and is probably ruling a lot, but hopefully not the judiciary. That's why we were all confident suing in Stuttgart. This was true until the end of last year when they exchanged the whole chamber. And now every claim fails. Before that, every claim in Stuttgart was won if you did your homework and substantiated well and had a good economic, let's say, report or theory of harm. But now every claim fails in Stuttgart. So this one failed as well, but it was first form shopping, Austrian going to, right? But it failed for the problems with the Legal Service Act, Till was in the previous panel describing. The problem there was the bundling of this didn't work out because in the main argument, the court said there is a conflict of interest between the funder and the victim. And this is enough. It's highly debated because this judgment came after Supreme Court air deal. And most of them that are active in the field of collective actions and assignment models say it will not hold, but it killed the action now in the first place. And it will take them also 5 years maybe to get that cleared before they get to the substance. Second case, Dortmund. We all love Dortmund when we are on the claimant side because this is, let's say, a role model court for a court that is specialized, has the knowledge, is not always claimant friendly, but at least you can talk to a judge who knows who is talking about. So Dortmund is really, really well acknowledged and the reputation is great. And
if you come to the right judge.
If you come to the right judge, that's true. But your case was older. Now it's the right judge. So sometimes you have to wait.
Just as a background, in the case that I mentioned in hydrogen peroxide, the European Court of Justice decided, I think it was in 2015, and the case went back to the Dortmund court, where it was clear that it was competent after the judgment by the ECJ, and then nothing happened for the next 5 years. And last year, actually, we settled the case with the last defendant without the court even picking up the case and deciding that it is just scheduling a hearing, for example, in order to hear the case. So, I mean, yeah, but that was not with the
now
current judge. Yeah.
Okay. And I always wonder when you talk about these time things, isn't there like a European Court of Human Rights judgment when saying everything beyond five years is an undue delay of process, right? But so far we've been invoking this in many cases, no one cares. Like the court doesn't care, it doesn't even mirror this argument in the, I don't know how to get there because I do agree or think that in some cases we have an undue or unfair delay of process, right? And especially in our private damages cases. Let me come to Dortmund quickly because it's clear, but it wasn't that clear from the beginning. It was in the car bearings cartel. It was a injunction claim, right? And the problem there was, can you claim at the seat of the assignee and not the assigner, right? And this was settled, and it didn't surprise me, but we, at least in Germany, didn't have a lot of precedents there. And Dortmund said, no, the assignment of claims doesn't change the jurisdiction, right? And the jurisdiction still follows Brussels 1A now. No, Brussels 1 is dead, Brussels 1A since 2015, or the national procedural rules. In that case, Dortmund declared itself not to be a competent court and referred it then to the place actually of the defendant, which was the interesting twist of that case. Then we have a Munich case, the regional court of Munich truck cartel, Spanish logistic company, for whatever reasons, we all know the reason, who knows the advocate of this case, but that is maybe for the wake, sued in Munich for damages, right? Is the place of jurisdiction is the joint litigant, MAN, right? That's why they were sued in Munich. The court admissed that claim, said it was the right jurisdiction. They had standing to sue there. It was closely connected, and this is in the truck cartel, if you read it, where the court had to rely on, because from 2004 on, the main agreements were made in Germany, in the German market. So I wonder if this judgment would have held in other jurisdictions with that reasoning, right? The reasoning for the connectivity, which you need, the proximity under Brussels 1A, right? To have a joint litigant place of jurisdiction was argued here by the court with the text of the decision, actually, that the cartel happened in Germany from 2004 on, and that I found interesting. The case failed for other reasons that it was not able to substantiate the claim or even the purchases. So that was like on a procedural side, nothing with forum shopping. And the last one I would like to mention, but you already mentioned it, and it is for me a very important case. It's Court of Justice Wikingerhof, right? Because Wikingerhof really touched, like I would say half of scholars and judges were on the one side and half were on the other side before Wikingerhof was solved, saying the contractual relation beats everything. But I mean, who has followed this case, and it's interesting there, said, no, it does not, if you claim that the contractual relation or the contract you concluded arose out of an abuse of dominance. And interesting, because you mentioned it, I don't want to go into detail and I want to finish there, and this is for me the open questions. None of the courts dealing with the Wikingerhof, not the regional court, not the higher regional court, not the Supreme Court, has so far assessed if the complaint about the abuse of dominance is justified. So me being a claimant attorney saying, I'll raise that if I want to have jurisdiction in a certain place, and this is enough, that I say you have an abuse of dominant position. Of course, this doesn't work with like an enterprise that has 5% market share. But Booking.com, I wouldn't be even sure that Booking.com has a dominant position in the German market. I wouldn't even be sure, but no one assessed that. It was, and this is for me surprising, this case. They just claimed abuse of dominance, and this was enough for a landmark judgment, which is good for the, let's say, forum shopping evolution of the, but in substance, I wonder how they will assess, right? And when it becomes arbitrary to raise that. But by that, let me finish here and hand over to the free panel, and gladly to you.
Okay. I have a case of forum shopping. It's not for Spain, but it's quite, for me, it was quite interesting and curious because it's really forum shopping. It's in the Netherlands. So if anyone Dutch is here, probably you can add. This is, of course, interestingly, it relates to beer. So it's a good time for a beer. It's Heineken. I am unable to pronounce it. So I will not be ridiculous trying to pronounce something I'm not able. But well, it's Heineken. And then that was the defendant. It was, everything happened in Greece, an affiliate of Heineken in Greece, which is Macedonian Trace Brewery. Well, it was sued by a competitor in Greece for an alleged abuse of dominant position, as far as I know. And what did they do? Well, instead of fighting in Greece, everything was located in Greece, everything. The beer, the parties, they said, no, let's look at, and there was an antitrust decision confirming the existence of the infringement. Well, the claimant looked at the parent company that was not the addressee of the decision. That's the good thing. The parent company was Heineken. It was located, its domicile was in the Netherlands. So the claimant went to the Netherlands and sued together Heineken and the Greek affiliate. In first instance, the court said, no, I don't have jurisdiction over the case. I have nothing to do with what's happening in Greece and the beers in Greece, etc. But in the appeal, they accepted the case. And they accepted the case. And it's funny because what you're saying is that, well, the idea was, let's first analyze whether there is a parental liability, because the anchor defendant here is the parent company. So let's see if the parent company, it's an economic unit with the affiliate, and then we decide on the merits. No, but the court did on the contrary and said, no, we need to understand on the merits whether there was really an infringement, and then we will decide on whether the parent company is liable. For me, it makes no sense because it could be a waste of time. But I think it's an interesting case on what we might expect in the future with digital markets. I see Miguel raising the hand. Of course, you will have the choice to do it. I think it's quite interesting what you're doing, for instance, in Portugal. You are having this issue of the iPhones that had a problem with the liquid and all the advertisement. It was sanctioned in Italy, and you were suing in Portugal. So this is what we will see in the digital market. What happens, what does Google does, it would affect all countries. Miguel, you wanted to say something?
1 second, Miguel, can I just add, because this is a thought there. And it's important to have those contractual provisions that have exclusionary jurisdiction, right? This was Wikinghof as well, because they had this in the contractual relation, and in the digital area, you have this in the general terms and conditions all the time, but they usually don't hold. So I think this is the lawyer's task in the future to try to develop a term that has exclusionary jurisdiction that holds, right? But sorry, Miguel.
Again, you stirred so much debate that I wouldn't be able to take up all the time that I would like to. But another very interesting case in the Netherlands of forum shopping, aside from the one you just mentioned, Patricia, is in the power cable cartel case, where the companies, several public companies from the Emirates, tried to use an anchor defendant, a subsidiary of the cartel participant. So it wasn't ascending liability, it was descending liability. And in that case, they decided, no, we don't have jurisdiction because the first instance court, we don't have jurisdiction, if I remember correctly, because there's no descending liability. And this was before Sumal. So now there's an appeal pending, and we don't know how that's going to, but maybe our Dutch colleagues, right? Two other thoughts that I'd like to add to this is that Julia is a great fan of private international law. And I think the great challenges that we have in this area really are with changing some of the rules of private international law. We've had failures that really shouldn't happen, like the Apple case that had two incidences, one in Portugal and one in France. The French one led to a referral where then they interpreted the jurisdictional clause and whether or not it was valid. The Portuguese court had the chance to rethink its previous decision after that judgment. And it looked at the case, it looked at the court saying, well, if you can foresee it, if you can foresee it at the time of the contract, then the jurisdictional clause is valid. And they said, yeah, this is perfectly fine. This is basically a contractual dispute, even though in that case, some of the abuses being alleged were infringements of the contract. So they weren't contractual clauses that were being invoked. It was things that were against the contract that they could not possibly have foreseen that would have happened. So again, there's a risk that these things will be interpreted by courts in a way that is convenient to them. And this is just a dream that I would leave for, I don't know if Patricia would like it, but a dream. Imagine changing the Brussels regulation so that there would be an exception in very limited circumstances, very special circumstances, only for consumer protection, where you could have an anchor consumer. Not an anchor defendant, an anchor claimant, but only for consumers. And that would solve the problem that right now, if you have a pan-European cartel, you have to sue in 27 member states. This way you would be able to sue at least in one, and then use opt-in to bring the others there. But one that has opt-out. So you can use at least the opt-out for that country. I don't know, I'll probably be dreaming.
I think that also from a defendant's perspective, and I go into very fast into the other factors, and then we can discuss and make it more dynamic. I think that from a defendant's perspective, it is also better to focus maybe in one or two jurisdictions, good ones, in which you know that the case is going to be analyzed on the merits properly. What I mean properly is that you have sufficient time to analyze economics, that you are not biased, that you don't have prejudges, that you go into the details of the econometric reports of both sides. You go into the details of the theories of harm. I heard, I think it was, it's a pity Helmut is not here because he went to the same conference as me. It was like 1 month ago, or 1 month and a half. And there was a French, a Dutch, and a German judge. And they started saying, well, if you're a claimant and you want to succeed, go to Spain. And I felt so bad, really, because this is the way that sometimes defendants feel. I prefer, if we have thousands of individual claims, I prefer to bundle them probably. Instead, because if I were a judge and I have on top of my table, and I'm sure that we have some magistrates here, it's much better to deal with one case properly than with thousands of individual cases. You don't have time to handle them. It's impossible. It's impossible. So I agree. I think that it's better to be, I don't know, I'm not going to say the CAT or Germany or the Netherlands or even in Spain if you want to, but to have 1 or 2 jurisdictions where you can really defend your case on the merits. You have their elements like language. I know that Germany is not the proper place. The Netherlands, by contrast, has become a very attractive country precisely because it accepts pleadings in English, which I think is fantastic. I hope it happens also in Spain. You also have not only the knowledge and expertise of the judges, I think is quite important, not only for the claimant side. I'm sure you prefer to go to a country where you really fight with a good report that, you know, going with nothing. So I think that for both sides, there are common elements. Costs, of course, speed. I accept and I agree that some jurisdictions are too low, but also going very fast is worse. For both sides, I agree. And maybe this is something very, very obvious when we talk about collective aggregation of claims. Simply just one remark: in Spain, unfortunately, we don't have collective claims. It's amazing now with the directive of collective claims that, well, competition claims are not in the radar, and it only affects consumers. So what about companies? I mean, I tend to think that relying on lawyers, just, you know, having subjective accumulations of claims is not enough. It's not enough, and it does not work properly. You can spread the risk because you have, how many courts do we have in Spain? 70 something. So you spread the risk. In one, you might have positive results, in other not. But I don't think this is a chess. I mean, I think it's better to fight and to defend your case, as I said, on an accumulated manner, if you want to, but to do it properly. So from a defendant's perspective, I think I would try not to spread the cases. And I don't know whether from the claimant's perspective, it is also better to have it centered in one jurisdiction. I don't know.
Yeah, maybe very briefly, because I think we're running out of time for the next panel. Yes, you need confidence in the court. I think it's really that you trust that you are in good hands. And I think that's a key element. And yeah, that is where a lot of the choice comes from. And that is, of course, also driven by experience. You have to give judges as well the chance to gain experience, to develop case law. And in that respect, I think Germany is actually a good place because there is a lot of case law by the Supreme Court on really key elements such as pass on, such as liability, evidence. I mean, it's really, I think a lot has been decided in Germany on the material substantial level, which is very, very interesting. So I wouldn't say I will not bring a case in Germany. I think there's a lot of elements which are positive. Then what we see now in the trucks case, and I think that's really the first time that claimants and defendants face these mass claims in parallel jurisdictions. And I mean, we're talking here about the multi-jurisdictional element. At a national level, it's already a problem, but at a multinational level, it's even more complicated to coordinate that and to also see, to avoid contradicting arguments, because in the end, a lot of the discussion is, the court in Granada said this, the court in Augsburg or in Nuremberg said something else. And that's what you tell to the judge in the Netherlands. And okay, so not really helpful. So, I mean, you have Article 15, I think, in the damages directive, which kind of gives judges the homework to look at what is happening in other jurisdictions. Yeah, so you should take account of what is happening in other jurisdictions. That's of course very difficult. How do you do that? How do you even understand the judgments? Yeah. So I think there is really a need for the Commission or whoever to set up, for example, case law that you can consider, that judges can read what is happening in other courts, that you have access to the judgments which are issued in other jurisdictions, so that you can read them and make your own mind, because you as a judge probably know better what another judge was meaning than having it told you by either the defendant or the claimant lawyer. And then possibly, like in the US, a kind of multi-district litigation that it's bundled somewhere. There again, okay, that is of course a huge challenge. Where do you go? But even if you would have that at least on a national level, that would already be very helpful.
I think we're running out of time. I could add like, but I spoke enough. Thanks, everybody.